All right, afternoon, everybody. Sorry again that I'm a few minutes late. I always underestimate how long it'll take me to get ready for stream. I know that the camera quality isn't that great for the webcam. I'm going to transition over into screen share here in just a little bit. I'm just going to open up chat on my phone and send out a quick text message, and then we'll get into it. Alright, let's see. Sorry, my aunt was texting me about places to buy last minute tickets for sports games and stuff since the Suns are in the playoffs right now. Alright. Just testing out chat, making sure that everything is working. Okay. I think that we are good to go. Alright. So today I am going to be going over a little bit more of stuff for crim law. The exam is on Tuesday. It's currently Sunday, and I have quite a bit to get done. The plan for today is to do some practice questions that he set out for us at the beginning of the semester. I'll go through those, see how well I did on them, and then we will go from there. Probably cover a bunch more of the PowerPoints and stuff that I didn't get to yesterday, but yeah, the plan for now is to go and do those practice multiple choice questions. Since it's a closed book exam, I'm not going to have my notes open, but what I will do is I'm going to have myself on a brand new sheet of this and write down my answers here, and I'll have it all open at the same time. That way, if any of you want to do any of the questions as well, you're more than welcome to. Also, before we get started, I wanted to show off, I have the classic law school t-shirt. If the bar takes 3 years to get to, it better be damn good. So, yeah. I think that every single law student that I know has some variation of this shirt. But that's enough putting this off. Let me go to open up the questions and we can get into it. I have to switch over to this. Again, sorry that y'all have to watch me going through OBS and everything like that over and over again, but it's the only way that I can do things for right now. I'm not going to time myself on these because I just want to get an idea of how much information I actually know. But yeah, these are all multiple choice questions. I think that there's about 30 of them. I'll go through these and then we'll see what happens from there. If anybody has any questions during this, feel free to pop it in the chat. If I look over and I see something, I'll answer it, but if I don't notice it, then I'll answer them once I go and start reviewing everything afterwards. And I decided to do a stream again because I'm just more productive when I'm on camera and I feel like I'm being watched. So yeah, otherwise I'd only do this today and not do any other studying, but today I can do the practice questions and go through some PowerPoints and stuff. And if any of you want, you're more than welcome to try your hand at this based on what you personally know and what we went over yesterday. We didn't go through the entire course yesterday, so you might not have everything, but you have at least some information and can probably answer a few of these questions. So without further ado, I'm going to get into it. If I get quiet for the next little bit, it's because I'm trying to focus on these. Just going through these first few, I already can tell I'm going to be in trouble. For any of you who were here for the stream yesterday, you will have some information to be able to answer some of these. Like number 4, we went over the harm principle. For anybody that hops in during this, I'm just going through some practice problems right now, and we'll go over them here in a couple of minutes. So right now I'm not talking too much, but if you have any questions on anything that you see, feel free to pop it in chat, and if I notice it, I'll answer. I think that there are about 30 of these questions, so we're about halfway through. Again, sorry I'm taking so long on these. I'm seeing just how unprepared I am when the exam is 2 days away. On the bright side, our professor said that these are the harder questions from last year's final, so even if I'm not doing too great, I should be fine. We're a little bit more than halfway through these. We'll go over the answers, and I'm guessing about 15 to 20 minutes, depending on how long each one of these questions takes me. Some of them are a little bit longer, so it might take a little bit more time, but if anybody has any questions along the way, feel free to ask. The fact that this is closed notes is going to be a pain in the ass. But that means that everybody's going to have to deal with the same issues. I feel like over half of these I'm guessing on. In fact, I am guessing on over half of them. I'll be at educated guesses, but I'll show you guys the way that I take exams and do problems here in a bit. Okay, some of these I'm starting to get more into a groove on. Also, I'm sorry that I don't have any background music or anything going. I thought about starting some up, but I didn't end up finding much. Actually, you know what? I do have Spotify open with some DMCA free stuff that I can play. I'm not sure how this will come out sounding, though. I can't hear it on my end, but you all might be. Alright, 2 more and we'll go over the answers. Alright, I am all done with doing the problems. Again, sorry that was probably pretty boring just sitting there watching me do these problems, but it's something that I had to do today. So let me pull up the answers and we will go through this and see where I messed up. And oh, perfect, this has the answers highlighted here as we go. Alright, so as we're going through these, if you have any questions on anything that comes up, let me know. I'll be grading myself as I go through. Okay, so this first one, which of the following correctly describes U.S. v. Jackson? This is a case that we went over yesterday while reviewing. It was talking about the constitutionality of proportional punishment underneath the 8th Amendment, and it's talking about how certain punishments are just uniformly unconstitutional for certain crimes. This was the one with the minor who was sentenced to life without parole for a non-homicide offense. They decided that that was unconstitutional broadly and that you could only sentence a minor to life without parole if they committed a homicide-based offense. And all of the stuff that is listed here was discussed in that case. The original sentencing judge used evidence of the defendant's prior conduct to figure out their sentencing. Posner, who was the deciding justice, said that the life without parole sentence exceeded anything that was necessary for general deterrence. And then Easterbrook, who was a dissenting justice, said that utilitarian goals such as deterrence and would support life without parole for that individual. Okay, this is relating to the same type of issue, the constitutionality of a law and whether it's legal to be enforced. So a law can be vague in one of 2 ways. One, in terms of lack of fair notice to individuals, and the other is lack of clarity on how it can be enforced. The first one seems like it could be unconstitutionally vague because it's vague as to who the police officers will enforce it upon, but there is an actual law that gives you notice that that you're violating it if you go above the speed limit. Disorderly conduct ends up being the correct answer because it's vague as to what disorderly conduct actually is. Sorry, I'm jumping around a little bit trying to figure stuff out. Again, if any of you you know what, I'm just going to run through these and grade myself first, and then I'll go through ones that I had issues with and jump to those on PowerPoints. just hit a run of ones where I didn't do too hot. So we'll have a lot to go over there in the middle. I did better than I expected in the first couple, but then I hit a very bad streak. Oh my gosh. Yeah, I have a lot to go over. Okay, I ended up doing awful on that, so we have a lot to go over, and starting with the first one that I got wrong, which is number 3. You know, I'm going to download this. That way I can have the PowerPoints open on the other side. Oh, you know what? I can get rid of... I can cut that. Close that. And then turn that off. Okay, sorry again that you guys all need to keep seeing all of that, but yeah. Okay. So, the first question that I ended up getting wrong was number 3, which is relating to somebody that was driving a car, hit a pedestrian, and they were distracted by their phone when that occurred. I ended up going with A, assuming that second-degree murder, but this is probably... Let me pull up the... Okay, I'm trying to understand why this isn't second-degree murder. You know what? I was conflating a lot of manslaughter with murder. This would be involuntary manslaughter because it's negligence. Okay. I'm going to be jumping over to my actual notes as well, so that way I can look at what I had. Most of this I have in my notes, and it would be very helpful to use the notes during the exam, but we aren't allowed to, so. Does this say what type of jurisdiction it is? No, it doesn't. Oh, you know what? This is recklessness, not negligence, because they are aware of the danger, because driving with the phone, you know that it's a danger, so that raises it from negligence to recklessness. Negligence, you aren't aware that there's a danger or a substantial and unjustifiable risk. Recklessness, you're aware of that risk and you commit the action anyways. So everybody knows that there's a substantial and unjustifiable risk of causing an accident when using a phone while driving. So that raises it to recklessness. And under the common law, recklessness or gross negligence is involuntary manslaughter, and under the model penal code, recklessness counts as manslaughter, and since that's not one of the options here, the correct answer is D. Alright, that makes more sense. I'm going to be jumping towards the ones that I was questioning on or that I got wrong. Like something that I tend to do a lot. Also, don't make fun of the score. Apparently these are tougher questions than what we'll have in general on our exam, and I started studying for this yesterday, so today and tomorrow I'm going to raise this up quite a bit. But I got 14 out of 30, but as you can see in the margins, oftentimes I'll write EG, that stands for educated guess. It means that I have a good idea of what the answer should be, but I'm not 100% certain. Typically I'll do that if I cross out like one of the answers and I'm stuck on the other three, or I cross out two of the answers and I'm stuck on the other two, and during an actual final, I take that and I go back to those questions whenever I have time. And that's just a good study tip in general. So 5 is one that I just made an educated guess on. And this is just, because I didn't have the definition of felony murder in front of me. If I had the definition right in front of me, I could have looked right at it. And right here in my notes I have reckless killings during specific crimes are presumed to show extreme indifference to human life. And that language right there, extreme indifference to human life, is necessary for most types of murder under the model penal code, that to raise it to one of those higher standards of murder. That's where you get that kind of depraved heart language and transition that we talked about a lot in class, but I didn't really go over that with the review yesterday. So anything that's related to murder I didn't get to yesterday, and that's going to be the bulk of what we're doing today, is talking about the different and types of homicide, the defenses to them, how you get away with it, and what the actual requirements are. So the next one that I didn't end up getting was number 9 here. Okay. For this, I put C. I put common law jurisdiction retreat is required before using force if the actor knows they can retreat with complete safety. I think that might be... Where did I have that? Oh, that's incorrect because that's only necessary when using deadly force, and that's not mentioned here at all. And B is correct because the language relating to that, I have right here in my notes. If the mistake is grossly negligent, then not defense to negligent homicide. If the mistake was reckless, then not defense to manslaughter. So you need to make a reasonable mistake in terms of what level of force is necessary. So I'll put here in my notes, only true for deadly force. Okay. Number 10, I made an educated guess on. I forget which one I was torn on. I was thinking of B a bit, but then I remembered what we went over yesterday with exculpatory and inculpatory errors, and I realized that C is probably the best answer that we had. Okay. Now we're going to get into a run of ones that I did not get correct. The first is 11. Which of the following is not a standalone crime? So a crime that has to be... They're looking for a crime that has to be connected to another crime. And I was torn. I thought B could be correct, but I went away from it because you can be convicted as an accessory even if the actual, even if the other individual that committed the crime isn't convicted. So I went with none of these being correct, but in order to even be charged as an accessory, you need another crime. So... Alright. Number 12. This one I was torn between A and C. I ended up going C on it. For those of you that remember utilitarianism from yesterday, it's about maximizing the good and the pleasure of society. So I kind of went towards C because if you take a look at the three main goals of utilitarianism in criminal law, there is deterrence, incapacitation, and rehabilitation, and that doesn't really seem to fit into any of them, but I can kind of see why it would be A. I'll have to look back over the units on rape law to cover that. 13 I also got incorrect. I put B. This is just because last semester I did a memo on specific intent and a general intent with intoxication, and a lot of the case law in that jurisdiction show that you can't use voluntary intoxication to show specific intent. You can use it to show general intent, but I forgot that it's not inadmissible, it's just only mere evidence. I need to take a look here at the insanity defense requirements again. Okay. Common law. I don't know why I don't have the common law one in here. Let me go and find that. I only had the MPC in my notes for whatever reason. So here, let's go to insanity. One of our defenses for, also here, this is important. This is one of our defenses when you're being charged with any type of homicide or crimes in general. One of the big ones is involuntary intoxication, which I thought was going to be the correct answer for number 13 that we just looked at. This provides a defense to reckless crimes and a defense. Oh, what I was looking at was voluntary intoxication, so that's inapplicable. Let me get down to insanity. There should be a... Okay, that's Model Penal Code. Okay. Under the common law, this is the rule that we get. It's a test to see whether or not someone's insane and can't be tried. First, you presume that everybody is sane, and it requires a defect of the mind that either the defendant didn't know the nature of their actions or the defendant did not know that their actions were wrong. So let me write that in my notes. The MPC is a little bit different. Common law insanity. One, presume everyone is sane, which is a big presumption. 2, you need a defect of the mind. This is basically any type of mental disease or disorder, anything that you can actually show. The defect of the mind, which either causes the defendant, sorry, my phone was vibrating, causes the defendant to not know the nature of their actions, or defendant doesn't know that their actions were wrong. And these all need to be a result of that mental defect or the defect of the mind. If you didn't know that your action was wrong because you just never were taught that killing somebody was wrong or something, that's not an insanity defense. That would still fall under negligence. Under the Model Penal Code, though, there's a different standard. A defense of insanity requires a mental disease or defect similar to the common law that causes the defendant to lack a substantial capacity to appreciate the wrongfulness of the conduct or to conform conduct to the requirements of law. So this is a different standard than what we have under the common law. It relates to whether or not you can appreciate what you were doing is wrong and whether or not your mental disorder doesn't allow you to conform to the requirements of law and society. So looking back at number 13, there's no evidence in this to show that the defendant's personality disorder reached the level of insanity in a common law jurisdiction, because you presume that everybody is sane unless there's proof otherwise, and there's not enough proof here in the question to show that they aren't sane. We'll go through a few more and then I'm going to go refill my coffee quick. But do you all understand why this ends up being D? And it's because you presume that everybody's sane first, and then if they do have a mental defect, you take a look and see if it causes the defendant to not know the nature of their actions, or it causes the defendant to not know that their actions were wrong. And because we don't have evidence of that here in the question, we need to go with the presumption that the defendant was sane. Okay. 14. This I put C because, again, I yesterday didn't get to go over all of the stuff for defenses, so I forgot what the requirements were for duress in each of the varying jurisdictions. You'll notice that this is a common theme with the questions that I got wrong today. I didn't have the distinction between the common law and the model penal code memorized, and so that's what we're going to spend a lot of time on today. So under the common law, which is what I thought was C, duress is only a defense if death or serious bodily injury is imminent. But under the model penal code, which ended up being the correct answer, the MPC requirement for duress is any unlawful force or threat of unlawful force. Okay, I went with C, but threat was present and immediate is a requirement in both. And if that's met, it's necessary, but it's not sufficient. You need to have that plus whatever the other requirement is, and at common law, you would need present and immediate threat of a death or serious bodily injury. Okay. Let's move on to 15. Okay, this I went with D because I didn't remember what state in the interest of MTS was, so let's pull up the notes on that case and see where I went wrong. This is a consent issue. State v. Rusk, no, it should be further down here. And I already passed it. Right back common law. Okay, here we go. So what was the scenario again? And the correct answer for this ended up being D. I went with A because I mixed up this last part of the rule statement. Statute is satisfied by any penetration in the absence of affirmative and freely given permission to the specific act of penetration. So MTS requires affirmative consent, and this relates to our theories of, or our 4 different models of consent. There's the totality of the evidence of non-consent. No always means no. Totality of the evidence of permission, and only yes means yes. And in this, I believe that they went on with totality of the evidence of non-consent for that MTS case. We are halfway through answering the questions. I'm going to go and refill my coffee and use the bathroom, and I will be back in just a minute. If anybody has questions on anything, feel free to let me know. I'll leave this open, and that way you guys can take a look ahead at the next couple that we have. So yeah, I'll be back in just a sec. Alright, I am back. We've got a few more of these to go through, and then we'll skim through some of the PowerPoints on anything that I was struggling with. Okay. 17 is going over solicitation and conspiracy. Okay, I missed the clue that this is an NPC jurisdiction, so that means that I needed to look at the NPC rules for when conspiracy is in effect. So and the NPC rule, this is way back in the notes. Conspiracy. The mens rea is the purpose to facilitate the commission of a crime, and the actus reus is the agreement to aid or engage in criminal conduct. And since B didn't have the purpose to facilitate the commission of the crime, they explicitly stated that they didn't want to, then they wouldn't meet the requirements that we have for conspiracy. But if we take a look at solicitation, we can see that A did meet those requirements, because the mens rea, or the mental requirement, is the purpose to facilitate the commission of a crime. A wanted to commit the crime, and the actus reus, or the action that's required, is to command, encourage, or request another to engage in criminal conduct. And they did ask their friend to engage in criminal conduct and drive them to commit an arson. So, okay, so that's why it is B and not A. I think that A also would have been guilty of conspiracy if B met the requirements, but since B didn't meet the requirements, then it's not conspiracy. You need two people to conspire in NPC jurisdictions. In common law jurisdictions, I believe that you can have conspiracy met by a single party. It's not dual party. Let me just double check that. Yeah, so at common law, conspiracy is bilateral and requires two people. Under model penal code jurisdictions, conspiracy can be done with only one party actually intending to commit the crime. So 17 A met solicitation requirements. B didn't meet conspiracy. Oh, I forgot to get rid of the coffee break sign. I realized the other day that my caffeine intake is way too high. I have been having like 5 cups of coffee, if not more, every single day. And I can't really cut back because it's final season. If I cut back, I'd end up screwing myself over. But I also can't... I'm not sure if I'm able to have that much caffeine before an 8 a.m. exam. So I'm going to need to be like up early and chugging coffee and bringing coffee into the final with me in order to not be going through withdrawals during it. Unless I cut back severely tomorrow, but I'm not sure. We'll see. Alright, that's enough of my caffeine addiction. Let's move on to number 18. This one I got wrong because I don't think that we read this case this semester. This is his exam from last semester, from last year, and I'm pretty sure that my section didn't read Graham versus Florida. I can double check, but I don't think that we did. This was relating to, just so that way I can make sure. Yeah, this is relating to constitutionality of stuff, so this would be back in legality here. Legality and proportionality. Proportionality, I know for a fact that we didn't cover this. So let me see. If it's here, then it might just have been one of the days that I missed and didn't read. Yeah, McBoyle, Yates, and these are interpretations. Chicago v. Morales, that was one of the options, but yeah, Graham wasn't, so okay. That's why I got that one wrong. At least I'm pretty sure. If any of my classmates see this and tell me that we did read Graham, I'll be a little embarrassed, but oh well. My rationale behind going with D is that Ewing v. California was our proportionality issue in regards to a specific circumstance. So that's why I thought that this fact pattern would match being non-proportional to the specific crime of a juvenile first-time sex offender. 19, one I also got wrong. Like I said, I got a shit ton of these wrong. So the correct answer is A. I went with D. Okay, let me take a look at what the requirement is for gross sexual imposition, because this is a separate crime besides rape that has its own list of requirements. Gross sexual imposition. It's only under the MPC, so only in Model Penal Code states. And for those of you who don't remember what MPC is, I talked about it during the live stream yesterday, and I can also make a video if people have questions on it. But MPC, gross sexual imposition. Any threat that would prevent resistance by woman of ordinary resolution, or the defendant knows that that the victim is unaware that a sexual act is being committed upon them, or mistakenly believes that it's with her husband. So, with D, by threatening to evict B, I guess that doesn't meet the requirement of a threat that would prevent the resistance of a woman of ordinary firmness or ordinary resolution. So, okay, I can kind of see why it's A. I need to put in my notes, remember what gross sexual imposition requirements actually are. Okay. After this, we got 20 right. 21. Okay. For this, I put A. This was one of those confusing cases, so I forgot what the rule was coming from this. So I think that this was under strict liability for us. Let's see. Morissette, Staples. Nope, not here. But it's in the next class. I didn't think it was under mistakes, but maybe it was. It could have even been under legality, but Regina v. Prince. Okay, Lambert. Okay. Oh, I forgot that this was decided based on the fact that the issue was non-feasance, not misfeasance. And in the problem that we have here, we have an issue of misfeasance. I went with the definition and with some of the stuff that we talked about yesterday with strict liability and why it should only typically be in force when it targets traditionally lawful, when it doesn't target traditionally lawful conduct, but it makes sense to switch it over to this. Sorry if I'm not explaining very well. I'm trying to understand why I personally fucked up. So, okay. Alright, so this is C just because of what they stated that the case was actually decided upon. If the statute targets something that's non-feasance, which means not doing something, then it would be unconstitutional because we don't tend to impose duties on people where none already existed. So I can't believe I got that wrong, but I got the other Lambert question right. Okay, so 23 ended up being C. I put D. Okay, this relates back to what we talked about before with the model penal code versus common law requirements for all of these different types of homicide. Okay, so common law jurisdiction. Where is voluntary manslaughter in here? Okay. Alright, so common law, voluntary manslaughter, unlawful intentional killing in response to serious reasonable provocation. Oh, that's where we get the provocation shit. Fuck. I forgot where that came into effect, and it's with voluntary manslaughter. We'll go over provocation right now. This is one of our other defenses to murder. It's not a complete defense, but it drops it down to manslaughter instead of murder. So let's go over that quickly. That'll cover this. Okay. We have different degrees of murder. I'll just go over murder in general now because we didn't go over it very much yesterday. But first degree murder, willful, deliberate, premeditated, and then second degree murders are everything else. So, and these tend to be synonyms in the law. So oftentimes you'll hear premeditated. That just means that you had time to think about it and think things through. Okay, and the question that we had with most of these cases is whether or not the killing in question could actually be premeditated. So, for example, State v. Guthrie. This dude was working as a dishwasher in a restaurant, and some of his coworkers started teasing him a little bit, and one of them took a towel, rolled it up, and flicked it at him and hit him in the nose. And for any of you who have played sports or something, this is like a common thing. You guys will fuck around with each other quite a bit. But Guthrie had some serious mental disorders, and he had a fixation with his nose and some body dysmorphia and shit. So when he got hit in the nose, it flicked a switch for him, and he decided, and he went and he stabbed his coworker in the neck right there. So the question was, is this premeditated? Did he have time to think about it beforehand? And the court said that premeditation requires actual reflection or the possibility of reflection, and in this case they said that yeah, this is premeditated. It's not manslaughter, it's premeditated. You took a look and he could have thought this through. Voluntary manslaughter is a little different though. Under the common law, which are states that follow just common law rules, voluntary manslaughter is an unlawful intentional killing in response to serious, reasonable provocation. So if it's basically provocation, anything that would inflame the passions of the ordinary man counts as reasonable provocation underneath the common law, and this is heat of passion murders and stuff like that, heat of passion killings. These count as voluntary manslaughter and did not murder, and the sentencing guidelines on these are a lot lower. So if you end up in a situation where you kill somebody, if you can prove that it was in response to a serious provocation, then you can potentially get it brought down to voluntary manslaughter. Some of the rules that we have regarding this are that words alone aren't enough to provoke, to count as provocation and reduce something to manslaughter. Like, there are only certain things that count as being sufficient to provoke somebody and reduce it from a murder charge down to manslaughter. So, in this case, this dude and his wife were arguing during the night, and he finally had a mental break. After she went to bed, he went ahead, went downstairs, grabbed a knife, came back upstairs. They continued arguing while they were arguing, he hid the knife behind his back, and then he stabbed her repeatedly, multiple times. And this was a woman who was threatening to get him court-martialed and get him discharged from the military. She was threatening him. She had previously assaulted him. But the question was, are her words and her threats enough to show adequate provocation and make this manslaughter as opposed to murder? And the court said, no, words alone are never enough to meet that requirement. You need to have something else. You need to have imminent fear. You need to have seen something in particular. Like, there's a list of things that you can see that would count as reasonable provocation, such as seeing your significant other cheating on you counts. But the next case that we'll get into kind of expands that even a little bit more. In this case in particular, they said that there wasn't provocation because the husband went downstairs, grabbed a knife, and he had time to cool off. And like I said a minute ago, provocation must be calculated to inflame the passion of a reasonable man and tend to cause him to act from passion and not reason. So things can only be provocation if they inflame your passions, or they would for somebody who is a normal person. So things such as, this case gives us certain categories of things that count for provocation, and they are when you're in mutual combat with somebody. This is a strange one to have because mutual combat itself is actually illegal in most states, but when you're the victim or you see somebody as the victim of an extreme assault and battery, like if you actually witness it, or viewing adultery, words alone are not enough for provocation to bring something down to voluntary manslaughter. The next one kind of expands it a little bit. This is Maher versus the People. This is an older case as referenced by the fact that it took place in a saloon. So the defendant heard that his wife was cheating on him. He saw her come out of the woods with some other dude, and one of his friends came up and said, "Hey, your wife's cheating on you." Then Maher goes into the saloon, shoots the victim and in an attempt to kill him, and he doesn't end up killing him, but the question is whether or not this is attempted murder or if it would be reduced to manslaughter. This is an attempt crime because he didn't end up actually killing the other person, but you still want to look at what the actual outcome would have been if they'd been killed to see whether or not it would be manslaughter or murder, to see what the sentencing guidelines are, even though it's an attempt and not an actual killing or homicide. And in this case, they said that the facts were sufficient to prove that he was acting out of passion. Provocation must tend to inflame the passions of a reasonable man, and this is a question of fact that a jury would take a look at. And this expands our conception of provocation to be quite a bit wider and something that juries now answer. Okay. Here's a little quirk about criminal law. Reasonable person isn't... It's a reasonable person under the situation. A reasonable person is assumed to not kill, but we changed that up a little bit for criminal law. The MPC is a little bit different. Model Penal Code is a little bit different. Instead of inflaming someone's passions, it is extreme emotional disturbance. So recklessly committing homicide or committing homicide while under extreme emotional or psychological disturbance for which there is a reasonable excuse. So manslaughter in states that follow the Model Penal Code is reckless homicide or homicide under extreme emotional disturbance. So not provocation, something different. It's very similar to provocation, but the standard is different. Not lower or higher, it's just different. Okay. I think that's enough of that for right now. We kind of have a better understanding of why 23 here ended up being C as opposed to D. Involuntary manslaughter if she was aware that she was getting sleepy before the crash. Okay, so involuntary manslaughter, I'm just going to take a look back at that. This is common law, so reckless or grossly negligent disregard of grave danger resulting in death. That's the standard that we have for common law involuntary manslaughter. The voluntary manslaughter requirement is unlawful intentional killing in response to that serious reasonable provocation. So there's no provocation here, so that's why it's not D. It is just a grossly negligent disregard to grave danger. So that's why we end up with C. Okay, we're going to jump to You know what, let's cover 24 because that's what we're talking about as well. Which of the following is an accurate statement of law? State versus Guthrie. That's one of the cases that we just looked at up here. So, State versus Guthrie. What's an accurate statement of law coming from this case? This is the one that I was talking about with the dishwasher who went ahead and stabbed his co-workers because they flicked him in the nose with the towel. Words are legally irrelevant to the issue of provocation. That doesn't really come from this. This comes from a different case. Words alone can be adequate provocation if a jury concluded that a reasonable person would tend to be inflamed by them. No, again, that's not what the case is about. The case is regarding whether or not there's time to reflect. All intentional, unprovoked homicides are considered premeditated. Again, no, this premeditated and intentional are two different things. You can have an intentional homicide that's not premeditated, such as provocation, when someone inflames your passions. The correct answer is D here. Premeditation can only be proven if the defendant had an opportunity to consider and weigh his decisions to kill prior to acting. This is you need time to cool off. There's no such thing as instantaneous premeditation. Premeditation doesn't require actual planning. It just needs space for the individual to reflect. And there's no set time period for what actually counts. But the killing must be purposeful, and the killer must have contemplated the intent to kill. And the rationale behind this is this last bullet point. A person who acts on sudden impulses is less dangerous, less culpable, and more capable of rehabilitation than someone who plans out and premeditates a murder. This is actually a contended issue. I personally think that someone who acts on sudden impulses that are severe enough to kill another person is far more dangerous than someone who takes the time to plan out a killing, because oftentimes those planned killings are in response to something particular and directed at a specific individual. Someone who acts on impulses, you have no warning of when a killing might arise from their actions. Someone who plans it out, you might well know that you could be in danger. Like if you know somebody who's a little on edge and you piss them off, sometimes you get that little tingle down the back of your neck, making you feel that you're in danger. But that's just my opinion on that. Alright, 25. And I put D for this one, so I didn't remember which memo was which. A was my other guess. I wrote educated guess next to this one as well. Which of the following arguments most cuts against the imposition of corporate liability for the conduct of employees acting within the scope of their employment? And this is just looking for the reason why we shouldn't impose criminal liability on corporations. And the answer is that corporate liability, i.e. criminally charging the corporation, will harm the employees and the shareholders who did not actually do anything wrong. The shareholders will be punished by lost profits for something that they didn't condone or didn't even know, and other employees will be punished for the wrongdoing of a particular individual just by the nature of the corporation itself being punished. That was actually my first guess, but I changed my mind for whatever reason. Okay. 26. I got this right, but let's break it down. So, I'm going to break it down because I also wrote educated guess next to this one, so let's see. The legislature in a common law jurisdiction, that's our hint right there, what jurisdiction we're looking at, so what rules we need to follow, recently passed the following law. It shall be unlawful to knowingly transport visual depictions of minors engaged in sexual activity. Which of the following best describes the mens rea required by the law? Okay. So, it's clearly not recklessness because that isn't mentioned at all. If it were recklessness, then that would be evident throughout it. They would have mentioned that specific mens rea. General intent is related to the intent to commit the intent to do the action in general, not the intent to commit the crime. So that wouldn't come into force because knowingly gives us a clue that this isn't general. You need to have the specific intent to transport things and to knowingly transport. So that's why it ends up being specific intent. I was torn a little bit when I got to strict liability, but the fact that it says knowingly cuts against that because you can't be strictly liable for something that requires knowing if you don't actually know. So if you didn't actually know that you were transporting the visual depictions, or you didn't actually know what those videos contain depictions of, you can't be held liable. You need to know that you were transporting something, and you need to know what it was depicting. So you need to have the specific intent in this case. If anybody has questions on our interpretation of statutes or anything, that we went over it a little bit yesterday, and also it falls into the mens rea notes that we have here and strict liability notes, and then it also falls under if you have a copy of the Model Penal Code, the MPC, it is section 2.02, I believe, that talks about the different types of mens rea and generalities. Even though this is a common law jurisdiction, it's useful to understand the MPC ones. So, moving on to number 27. Okay, this was D, or no, this was B, and I put D. Okay. Which of the following is not considered fraud in the factum under the common law of rape? Okay, this will pull up the notes for deception. There are two different types of fraud for rape. One is fraud in the factum, and one is fraud in the inducement. Okay, so fraud in the factum, fraud in the inducement. Okay, these are both common law. Let's double check. Hi, Pinky. How's it going? We'll double check what this is taking a look at. Which of the following is not considered fraud in the factum under the common law? You always want to take a look and see whether it's common law or model penal code, so that way you know where to look. A lot of these, it was hard to do because I couldn't use my notes because it's going to be a closed book exam. But since we know it's common law, we know that we're looking at the common law rules that we have here. So, fraud, which of the following is not considered fraud in the factum? So our rule of fraud in the factum is sex is non-consensual if the victim is unaware of the nature of the act. Okay, that's our definition. Now let's try and apply it. They're unaware of the nature of the act. Deception about whether the conduct engaged in is in fact sexual intercourse. Okay, this is relating to the nature of the act. If the victim doesn't know what type of action is going on or what the nature of the action is, then it counts as fraud in the factum. So this is fraud in the factum, so that's not our answer. We're looking for what's not fraud in the factum. B, deception about any fact that was an explicit condition of the sexual intercourse. This is going to end up being our correct answer because this ends up being fraud in the inducement, something different. Fraud in the inducement. Sex is consensual even if the victim is deceived about a collateral matter. So, about a matter as to who the individual is. So, when you impersonate somebody, or deception about the purpose of the sexual conduct, like why you want to have sex. If you tell somebody you want to have sex because you're dying and it's your last wish, that's fraud in the inducement, and that sex would actually be consensual if the other person agreed to it. Or if you tell somebody that you're a doctor and to get them to have sex with you because of that, that is consensual because of fraud in the inducement, at least in common law jurisdictions. But if you lie to them and you convince them that this isn't sex that you're having or something, or you pretend to be someone's spouse, then that would count. Then it would be non-consensual, as the victim is not aware of the nature of the act. So B, we already have, is not fraud in the factum. This is fraud in the inducement. And C is one that we just took a look at, deception about whether one's sexual partner is in fact one's spouse. So if you pretend to be someone else's spouse, that is non-consensual sex, and that counts as fraud in the factum. If anybody has questions about that, we can go back over it in a bit. But for now, let's move on to 28. The correct answer here is A. Let's break down why. Which of the following accurately describes the difference between factual impossibility and legal impossibility at common law? This goes back to what we had before. I think it was under attempts. I spent a decent amount of time going over this yesterday because a lot of people have issues with this. So, mistake of fact, mistake of law. Oh, actually, it's in the next one. And all those pictures of cats. Factual impossibility, legal impossibility. Okay, so here is the information that we need. We are talking about factual impossibility versus legal impossibility. So, factual impossibility is that the crime was never capable of being committed because of a certain fact of nature. So, say you thought you were breaking into someone's house and committing a burglary, and one of the essential elements of burglary is breaking and entering at night into a building used as a dwelling. So say that you thought that this building was somebody's house, but in fact it's corporate headquarters. That means that you were wrong about the fact of what type of building it is. So you committing burglary is factually impossible because you can't be breaking into a dwelling if you're breaking into a corporate headquarters or a corporate office. That is factual impossibility. Legal impossibility is when you think that something is a crime, but it's actually not a crime at all. So if you think that walking alone at night, this is the example I used yesterday, if you think that walking alone at night outside is illegal, and you go and you do it anyways, we can't charge you with anything because there's not an actual crime that you committed. So, with that in mind, let's take a look at what the answers are. Okay, the correct answer is factual impossibility does not exculpate an attempted crime, but legal impossibility does. This relates to why I talked about if something's legally impossible, we can't charge you with anything, so you're exculpated. You aren't charged with it, you get away with whatever you were doing. Inculpatory is the opposite of that, and it doesn't help you as a defense at all. Factual impossibility, like we see down here, is inculpatory. It's an inculpatory error. Legal impossibility is an exculpatory error. So that's why number one, or A, ends up being correct. I actually went with D. I don't know why. Let me read it through. Factual impossibility occurs when the defendant believes that their conduct is against the law, But legal impossibility occurs when the law does not criminalize the conduct actually engaged in. Okay, I messed that up just because this wasn't the actual correct definition of factual impossibility. It had the correct definition for legal impossibility, but I was rushing through it and saw occurs when the defendant believes that their conduct is against the law. That's not actually a requirement of factual impossibility. So, okay. 28. Remember factual impossibility requirements. Okay. 2 more. Alright. 29. This one is a long read, so we'll go through this. D is going to stand for defendant most of the time, and V will stand for victim, so I'll just call them defendant and victim. So defendant is a recently divorced 43-year-old woman. One day while at the gym, she was approached by victim, a younger man. The victim flirted profusely with the defendant and asked if he could take her out to dinner. The defendant asked the victim's age, and the victim replied that he had recently turned 18. The defendant allowed the victim to take her to dinner, and later that evening, the defendant and victim had sex at the defendant's house. The victim was in fact only 16 years old. When the victim's parents found out about the encounter, they reported the defendant to the local police, and the defendant was eventually charged with statutory rape. The defendant and victim live in a common law jurisdiction, hint, where statutory rape is defined as sexual intercourse with a person under the age of 18. Which of the following is the most likely result? Okay, so we're in a common law jurisdiction. The question is about statutory rape. The correct answer is D. The defendant is acquitted because she did not consciously disregard a substantial and unjustifiable risk that victim was underage. This threw me a little bit. I thought that was A. I remember that statutory rape is typically strict liability, but I guess that's not always the case. I'm guessing that that's maybe under the model penal code that is strict liability. So let me jump back to the mens rea requirements for rape. Hang on. I'm not sure where that's from. Oh, here it is. Okay. Mistake of fact. Under common law, a mistake of fact must be both honest and reasonable. Okay. And this is typically relating to consent, but you can use this in the application of age as well. So, a mistake of fact must be both honest and reasonable, and because of the defendant's actions in here, it looks like they reasonably believe that the victim was actually 18. Okay. Alright, that makes a little bit more sense. I'm going to write down mistake of fact. Alright, last one, I got this correct, but we'll go over it anyways. According to H.L.A. Hart, what role should the theory of utilitarianism serve in criminal justice? We didn't really talk about Hart very much yesterday, but if you remember, I mentioned that Hart is the head, he's the leading mind behind mixed theories. mixed theories of why we should punish individuals and why we should criminalize actions. So, with that in mind, you need to view that we have both utilitarianism and retributivism combined. So, what part should utilitarianism play in that? B is very clearly incorrect because utilitarianism doesn't care about desert at all. A also ends up being incorrect. This one's a little bit harder to explain, but it's because utilitarianism would function more as a proportionality restraint or constraint as opposed to distributional. There's nothing in utilitarianism that says who we should distribute the punishment to. They don't really care. They go off the deep end. So you can distribute punishment to whoever you want so long as it would maximize utility. But the three main purposes of utilitarianism are a good general justifying aim. Those are the deterrence, both specific and general, rehabilitation, and incapacitation. Those are all good aims that we should be striving for, as opposed to just punishing people because we believe punishment is good in and of itself. Alright, I know that we've covered a lot. I am going to top off my coffee, and if anybody has questions about anything, feel free to drop them in the chat. I'll be back in just a minute and I'll answer any questions that you all had. Here, let me mute this quick. Alright, I am back. And yeah, okay, that took us about 2 hours to get through all of these practice problems, practice questions. Now I think that we'll spend maybe about half an hour going through some of the PowerPoints again and taking a look at the differences between MPC and common law jurisdictions for all these different things that we have. I have most of them in my old notes, but I want to refresh myself on them. And yeah, if y'all have questions as we go, we'll figure it out. But I'm going to copy those down again and just do some review on it. If anybody has any other suggestions, you're more than welcome to pop them in the chat. Okay, so we left off yesterday with the beginning of studying rape. And now that we've jumped around, covered a bit of it today. I think I'm going to jump to consent because we covered force a lot yesterday. This I mentioned earlier. This is gross sexual imposition. Under the model penal code, this is a separate charge as opposed to rape that a lot of times will be used, since under the MPC they don't require actual force, I don't believe. Yeah, force can be used, but threats of force are oftentimes, it's questionable whether or not a threat would count as rising to the level of rape under the MPC. So they have gross sexual imposition as a separate charge, while the common law would just take that and try and make it count towards rape. So again, this, I already mentioned it earlier, but gross sexual imposition. Alright, this is MPC exclusive, and it's any threat that would prevent resistance by a woman of ordinary resolution. And this is used as a replacement for a rape charge. So say that somebody is making a threat that's non-violent. So if you're threatening somebody saying, I'll break your arm or I'll kill you if you don't sleep with me, that would fall under rape for both MPC and common law. But if somebody's threatening you with something else, such as, I'm going to do X, Y, and Z that is going to destroy your family, like they're threatening you with blackmail or something. If the blackmail is severe enough that it would prevent a normal person from resisting, then that would end up falling under gross sexual imposition. But most of the time in the model penal code jurisdictions, if you threaten somebody with blackmail to induce them to have sex with you, that doesn't meet the requirements of rape because it's not a threat of force. Make sense? There are also a couple of other added requirements and stuff, or added factors that can go into effect, such as if the defendant knows that the victim is unaware that a sexual act is being committed upon them, then that would count as gross sexual imposition. It's questionable why that wouldn't be rape and just fall into the unconscious/unaware category for the model penal code, but I guess this is a better safe than sorry thing. Oftentimes you want to have as broad legislation as you possibly can. So that is everything that we have on force relating to rape and threats. Now we will move on to consent. And we're just going to be looking at these black letter law slides for right now. These are the same as we had on the previous PowerPoint, so they aren't that important. Let me just double check whether or not this ends up being a model penal code or common law state. Okay, this had a specific statute. We talked about this a little bit earlier going through the questions. This had a specific statute classifying rape as sexual penetration using physical force or coercion. There was no actual definition of physical force, and they said that physical force was met just by penetration in the absence of affirmative and freely given permission. So the MTS standard is totality of the evidence of consent. You need to show consent in order to not be charged with rape. So MTS, then these are just someone's initials. Oftentimes with more gruesome cases or cases involving minors, we will use initials and have the state or the government prosecuting on their behalf as opposed to actual cases involving the particular person. So MTS, out of this we get a totality of the evidence of permission standard. So all of the evidence of permission must be taken together and show that there is actually consent. At least I'm fairly certain that that's the rule that we got this. Yeah, affirmative and freely given permission to the specific act of penetration. Actually, no, that falls under only yes means yes. So you can only, yes means yes. You can only classify something as consent if there's an actual yes and in the affirmative to that specific action. Only yes means yes, and this requires affirmative and freely given consent to the specific action. There are a couple of instances where consent is just categorically invalid. Sorry, I'm just finishing up that note. Okay, so there are certain instances where consent is just uniformly invalid, and these often fall under age. If they fall below a certain age requirement, then they cannot consent. Under the model penal code, the minimum, like anything under 10, I believe there's no form of consent at all. Individuals with intellectual disabilities cannot consent. There are certain intellectual disabilities. People who are sleeping and unconscious cannot consent. Someone who is severely impaired or intoxicated cannot consent. That's an iffy one that we struggle a lot with in current cases as to, particularly on college campuses, whether or not a individual is intoxicated enough that they cannot give consent, and what happens if both parties are intoxicated. These are all kind of cutting edge legal issues that could go either way. And then there are certain categories of relationships that you just cannot consent, like a patient cannot consent to sex with their psychiatrist. Some states have that for general therapists as well, and in general practice, most of the time you just can't do that. I know that for lawyers, the ABA model rules, so our moral code of conduct, says that we cannot have sex with our clients unless we were already in a relationship before they became our client. Once they're not our client anymore, we can have sex with them, but it's to discourage us from using our clients as our dating pool and to try and stop us from getting into too much hot water. A lot of people in my class aren't huge fans of that rule, and I can't say that I'm a big fan of it either, but I can see the rationale behind it. Alright, that's enough on consent. I know that I kind of breezed through that, but a lot of this we talked about when I was going through the questions earlier. Again, these are just good questions to ask yourself to see how well you're understanding the material. But, yeah. Let's move on. This is what we were talking about earlier with fraud and deception when inducing somebody to have sex with you. So, a lot of the time, deception and fraud doesn't negate consent. It only negates consent if the fraud or the deception is in relation to the nature of the act. So if you are a doctor and you convince somebody that you're going to be treating them medically by having sex with them, but you don't call it sex, you say, oh, there's this new treatment where we inject a male with a certain medication, and the only way that it's able to impact you is if he has sex with you and ejaculates inside of you. If you treat something like it's a medical treatment, and to convince somebody to have sex with you because of that, that is fraud in the factum, and their consent to that doesn't count. It's non-consensual sex because what they were consenting to was something that wasn't sex. They were consenting to a medical treatment, even though it wasn't actually a medical treatment. This also counts if you pretend to be someone else's spouse. They're consenting to sex with their spouse and not you, so that is non-consensual intercourse. But you are able to use fraud, deceit, and deception for certain ways to induce the other person to have sex with you. So if you impersonate a doctor, a lawyer, a pilot, pretend that you're someone rich and famous, and you get somebody to have sex with you because of that, that sex is still consensual. They're consenting to have sex with you. It doesn't matter that the you that they're consenting to have sex with is not real. Since they consented to the sexual action, it is consensual. That's the big thing. If they consent to that specific sexual action, then it oftentimes will end up being consensual. If you deceive somebody about the purpose of the sexual conduct, like if you say that you want to have sex with them because I'm trying to think of an example to this. Oh, because you're dying and it's your last wish that you have sex with them, but you aren't actually dying. That's fraud in the inducement, but if they agree to have sex with you anyways, then it's consensual. So, any questions on fraud? Also, we still have gross sexual imposition as that other case, or that other charge that you can bring in model penal code jurisdictions. Let's see. what was this case about again? Okay, this is just relating to the mens rea requirement, or the mental state that you need. So when you make a mistake, it can be a defense in the common law jurisdictions if the mistake is honest and reasonable and the defendant's conduct is otherwise blameless. And in model penal code jurisdictions, whenever a mistake negatives the required mens rea. So that's a weird concept, but it's something that we have a lot in the model penal code. If you make a mistake that would negate the required mental state, then it works as a defense. So say there's a crime that requires knowledge, but you make a mistake that would get rid of your actual knowledge of something. So say you thought that you knew something, but you didn't, like you dreamt something to be true, but you didn't actually know it to be true. That would negative the mens rea for knowing. So you could use it as a defense to that specific element of the crime. And oftentimes that's all that you need. In order to be found guilty of a crime, the prosecution needs to show that every single element of the crime was met. So if you can show that you didn't have the required mens rea or mental state necessary to commit a specific element of the crime, you can get off scot-free. Or at worst, it'll be reduced to a lower crime. This I talked about quite a bit yesterday when I was talking about mens rea and actus reus. Mens rea, again, is just the mental state necessary to be found criminally negligent for a specific crime. Actus reus is the action that is required for you to be found guilty of that crime. Alright, I think that is almost everything that we had on rape. So now we're going to get into the fun part, and this is all of our different types of homicide. You know what, since I'm here anyways, I might as well write back down these notes. Fraud in the factum. Under the common law. Sex, non-consensual. If the victim is unaware of the nature of the act. And then fraud in the inducement. I'm just rewriting these down for my own sake, because it'll help reinforce it later. So, sex is consensual, even if the victim is deceived about collateral matter. Okay. Now we are on to homicide. This is a fun one. There's a lot that goes into homicide, so this may get pretty bulky. I'm sorry, I had my drink there, and I was in the middle of a sentence, but I decided to take a sip anyways. I'm still not fully used to streaming in and of itself. I have a ways to go to get used to this, but back to the material. Since there's a lot that goes into homicide, I'm not sure how much of it I'm going to get through. I might do part of it today, part of it tomorrow. I don't know if I'm going to live stream it again if I do it tomorrow, since that's the day before the final, and I have some appointments in the morning, but we'll see. I'm not entirely sure, but I'll talk about that more once we get to the end of this stream. I'm going to go through at least a little bit of this stuff on homicide, and then we'll see what happens. Alright, so what is homicide? It's any killing of a human being. There are a ton of different types of homicide that we have criminal charges for. Those are murder, manslaughter, negligent homicide, and we also even criminalize suicide. Oftentimes you can only get a conviction for that if it's an attempt, but that's for obvious reasons. So, we have the first thing that is in front of us is murder, both at common law and under the Model Penal Code, and this is drastically different. Under the Model Penal Code, we have these very specific mens rea. So let me start writing this out in my notes as well. Murder. Under the Model Penal Code, it's purposely or knowingly committing homicide. So our two highest levels of mens rea. And homicide happens to be the actus reus for all of these homicide crimes. Causing the death of another person or causing the death of a human being is just going to be the actus reus for all of these, or the guilty action. So purposefully or knowingly committing homicide, or recklessly committing homicide. While demonstrating extreme indifference to human life. So, under the Model Penal Code, murder is any homicide that is one of those top three mens rea. The only difference between the three is if it's reckless, you need to be manifesting extreme indifference to human life. This is different from murder at common law. At common law, this is an unlawful killing with malice aforethought. So homicide, our actus reus, with malice aforethought. That's our mens rea. And again, this is kind of strange. What does malice aforethought mean? We don't have this strict definitions like we do for the Model Penal Code. Let me write this down. Malice aforethought. At the common law, we typically distinguish this between first degree and second degree murder, and this is kind of what we were talking about before with intentional versus like heat of the moment. We'll get into that a bit more later. What I was saying though, what is malice aforethought? This isn't a full-on definition. Like they said, it's a term of art and it will differ from jurisdiction to jurisdiction, but it encompasses almost all intentional and unprovoked homicides, and also it will cover a lot of reckless homicides where there's indifference to deadly risks. So this gives us a list that is very similar to murder under the Model Penal Code. Reckless homicides reflecting indifference to deadly risk, that counts as the reckless homicide while demonstrating extreme indifference to human life. So a lot of what's in malice aforethought will track with something that we have in the Model Penal Code definition of murder. These are just some examples of what malice aforethought counts as. If anybody has questions on those, let me know, but we're going to keep moving. What are the 2 degrees of murder? First degree murder are willful, deliberate, and premeditated murders. So these are often used as synonyms for each other. I talked about this a little bit before when we were going through the answers for the practice problems. Second degree murder is everything else that falls underneath that murder definition that we had. So defining first degree murder. We want to look at if the homicide itself was deliberate, willful, or premeditated. And the first case that we had for that was Commonwealth versus Carroll. So, criminal case where the husband argued with his wife. They had a loaded gun on the windowsill above their bed. And after they argued, the wife went to sleep. And a few minutes later, the husband reached up, grabbed the pistol, pointed it at the wife, and shot her, I believe, twice. And the question was, is this deliberate, willful, or premeditated? Or is it in the heat of passion? And they said that if you intentionally take the gun and aim it and shoot it, that counts as premeditated. Particularly because this guy had time to reflect. His wife was asleep next to him. So, premeditation doesn't actually require any elapsed time between you forming the intent to kill and actually killing. That's a kind of misconception that a lot of people have. When people hear premeditated, they think planned in advance. You form the intent to kill, and then you go and create a plan, and then you execute it. You don't, so long as you can think it through, it's premeditated. If you deliberately do it. This is also where we get the Guthrie case that I talked about before. There's no such thing as instantaneous premeditation, but premeditation still doesn't require a plan. It just requires that there's a space where the defendant could reflect. Actual reflection oftentimes isn't required, but there has to be at least some period of time where they could reflect. And we will take a look at... Here's some stuff on when we can draw evidence of premeditation or show that premeditation existed. This isn't always necessary, but here, I'm going... Okay, that was the basics of murder and what we have. I actually think that I said that we do about half an hour of going through these, and it's been half an hour. I think that I might actually end stream now so that way I can go and take a bit of a break and probably do some more studying later. The practice questions took a lot longer than I expected, but today was fairly productive. I don't know if I'm going to do another study with me stream tomorrow. Probably not, since it's the day before the exam and I have some other stuff that I've got to get done. But if I do, you all will know about it. For now, I think I'm going to log off, chill out, and then do some more studying later. If I don't do a study with me stream, then my next one will probably be on Wednesday to finish doing some prep for property, which I have on Friday. I'm not going to do one on Tuesday because that's the day of my crim law final. So, yeah, but we'll see. I'm undecided as to whether or not I want to do another one in general, but I'm leaving my options open. Thank you all again for watching. I appreciate you stopping in, and I will